the case to proceed, the witnesses or evidence must be collected and compiled in a applications book or appeal book or whatever you call the book. And if any facts that we disagree, then those facts will be tried out. Those things are not yet done. And tomorrow, 3 of the 4 or 5 days' time, the case will, substantive hearings will take place.
Welcome to PNG Trends Burner. In this video, we present a comprehensive update in response to our recent YouTube poll concerning the Supreme Court hearing on the vote of no confidence motion. Watch till the end to know the powers at play and stay informed. Let's delve into the details and dissect the unfolding events. On June 5, 2024, the Speaker nitpicked a defect in the VONC due to an issue with the name of the MP for Middle Fly. This was the fourth time the Speaker, Job Pomut, found a technical fault in the VONC motion and ruled against it being tabled in Parliament. This revelation caused a ripple in Parliament and quickly became a trending topic on social media and mainstream media, because many Papua New Guineans saw it as an act to delay the VONC motion.
There's plenty of legal stuff. Suppose country, the leaders of the country, got confidence for government, only got the right to express in this level, this level. Yeah. This is it. So please, you can write decision and you can finish themselves. Suppose do that, Mr. Speaker. And you know, you go best in government, so you should resign.
The Supreme Court began proceedings on the VONC case on June 13, 2024. Justice Derek Hartshorn, the presiding judge, instructed the Speaker and the Attorney General to submit their application by June 14, and subsequently adjourned the matter to June 18, for further hearing. Fast forward to July 1, Justice Hartshorn, acting as a single Supreme Court judge, issued directional orders for the VONC case. This pivotal order set the stage for the VONC dispute, affirming the opposition's right to proceed with the court, given the national importance of the VONC.
Today's hearing before the five-man bench was on the issue of the opposition leader's standing. So that's for the court to determine, and whether the opposition leader has sufficient interest and whether he's bringing proper issues to the court. So the court sat and heard that issue today, whether the opposition leader has sufficient standing. And we argued against it. We're saying that the questions being brought to the court's attention are not proper questions. On that basis, we argued against the opposition leader's application for standing today. The court considered arguments and will give a decision tomorrow. So if the court finds that the opposition leader has standing, the proceedings will progress to the normal course until whichever stage they're disposed of, either at the early stage of competency or it will go to a final hearing and then the court will make a final ruling on the application itself.
I am pleased to announce to the people of Papua New Guinea that the judges this morning, in their wisdom, have stated very clearly that I have standing to bring the VONC application to the Supreme Court, and I'm not a mere busybody. So, to our people of Papua New Guinea, the case now will move to substantive hearing, and we, as the opposition, will be moving very fast to make certain that it is presented to the Supreme Court within this week, possibly next week, so that we can advance the VONC court issue on what we think is an unfair issue by the government. So, ladies and gentlemen, today is a victory for not only the opposition, but it is a victory for the people of Papua.
On July 19, 2024, the opposition secured directional orders from Justice Hartshorn for a comprehensive hearing on the substantive arguments of the VONC application, slated for August 1. Justice Hartshorn underscored that the VONC matter is prioritized through the Supreme Court's expedited proceeding. He made it clear that all documents must be submitted on 2 occasions, June 13 and July 19, leaving no room for maneuvering.
representative of the Speaker of Parliament and Attorney General. They all made their submissions about the procedures that the court should follow, and in the end, the ruling we have received today is for an expedited proceeding. An expedited proceeding which is very, very important for us considering the nature of our case. We, as the applicant in the proceedings, have, which is to get a final judgment before Parliament was scheduled to resume in the first week of September.
This means the case will be heard and decided more swiftly than usual. All parties must submit all relevant documents relating to the substantive matter by July 26, 2024, and a full hearing will be held on August 1, 2024. The court documents should now have been submitted by the Attorney General and government lawyers, and the matter is now under the jurisdiction of the judges. This raises questions about why the Attorney General and government lawyers are seeking to validate the documents and why they are questioning Justice Derek Hartshorn's decision.
The case to proceed, the witnesses or evidence must be collected and compiled in a applications book or appeal book or whatever you call the book. And if any facts that we disagree, then those facts will be tried out. Those things are not yet done. And tomorrow, 3 of the 4 or 5 days' time, the case will substantive hearings.
On July 29, 2024, a 5-man Supreme Court bench heard an application by Attorney General Pilar Naninggi to set aside orders for the opposition's substantive hearing scheduled for August 1. This move by the Attorney General, on behalf of the government, is perceived by the opposition as a delay tactic to buy time and potentially alter the course of the court hearing.
So we expect that the full court will make the decision on Wednesday to allow the substantive matter to be heard on the 1st. So we can have Parliament recalled in August so that we can allow the vote of no confidence to proceed and we can appoint a new Prime Minister of Papua New Guinea to get the country back on track.
In essence, the government lawyers and Attorney General Pilar Naninggi are attempting to halt the full hearing on the substantive arguments of the VONC application scheduled for August 1. If this impacts the July 19 decision, the VONC case could be prolonged, redirected, or potentially halted.
So if the Supreme Court rules tomorrow and finds that the opposition leader has no standing, then the matter comes to an end and is complete and the proceedings are done.
However, the opposition has a strong case, as evidenced by the July 1 decision. Justice Derek Hartshorn has laid the groundwork for all parties to submit all court documents. There is no room for delay, and the court will exercise its judgment unless the government lawyers present a compelling case. Currently, they are challenging Justice Derek Hartshorn's decision, not the main VONC decision. On July 30, 2024, a full court comprising Justices Alan David, Joseph Yagi, Lawrence Kangwea, Jacinta Murray, and Haitlai Palumkiel heard the submissions from the parties and reserved the decision to July 31. The decision to set aside Justice Derek Hartshorn's July 19 orders will precede the August 1 substantive hearing on the VONC matter. To clarify, a substantive matter refers to the original rights and obligations of individuals. In the context of the VONC case, the substantive matter set for August 1 refers to the main arguments and issues related to the vote of no confidence, which will be heard and decided upon by the court on August 1. This gives us a glimpse into what could transpire if the full Supreme Court bench upholds Justice Derek Hartshorn's decision of the July 19. If Justice Hartshorn's decision on July 19 for the full hearing on the substantive arguments of the VONC application take place on August 1 is upheld, the substantive court hearing will proceed on August 1, with the decision to follow.
People blomi lamanu soli harem. Now al pigini blomi family blomi meri oli harem. Semi al tuba karem. So based on decision block court. So bosol tok mi work mi decision block committee based on names now this la. Straight now li rausim. Behind him thinking block committee. Prime Minister, me ba mi resign as speaker.
As you can see, the situation is complex. It is a legal battle with the powers of government at work against the opposition, with the Supreme Court acting as the referee. Decision can go either way. We encourage you to check out the description for links to the story from day one and watch the videos to gain a comprehensive understanding of the situation. Don't miss out on our latest videos in the playlist here. Click the round button in the middle now to join the PNG Trends Burner community. Stay informed, stay engaged, stay connected. Thank you very much.